Hi, I'm Soheila Azizi. I'm one of the panelists on the CAMS mediation, and CAMS stands for California Arbitration and Mediation Services. Believe it or not, some people still ask about what mediation is. And since I'm an attorney, they're asking if attorneys could participate in a mediation session. So I'd like to say a few words about mediation in a litigated case. As a legal professional myself, I'm always striving to accomplish the best outcome for the clients, whether they are my clients or their parties in a mediation. So when they choose mediation as one of the ways of resolving their conflicts, my commitment is to make sure that the matter is resolved in the best possible way and in a win-win situation. In a lot of emotionally charged matters, such as probate cases and family law, where the family members who once were in love with each other as a couple or were in a loving relationship as a family come to parts because of some dispute that has arisen. And many times attorneys who take on these cases are not ready or willing or interested in the emotional pieces. And they reach out to me to get in the middle of all of that and try to calm the situation by speaking to parties, by mediating the process. And that's the beauty of the mediation, where a neutral gets in, where the attorneys could argue their legal points, but a mediator could facilitate the emotional. People often ask if mediation is effective in the sense of voicing the interests of the parties or the position of the parties. In mediation, we try to move the parties' position so that they could see each other's position and possibly move towards a resolution where everyone keeps that control over the outcome. However, everyone needs to make somewhat of a compromise. That does not mean that you're losing the power in mediation. If anything, you're gaining control over the process as it's compared to a litigation process. In a litigation process, the attorneys who always are looking out for the best interests of the parties have no reason to not want to advocate the party's case. However, in an adversarial system where the court will require that both of them will put on the gloves on both sides, maybe there are more than two sides to any dispute, there would be many sides. Each is fighting for the best interest of their clients. That may or may not be what the client wants. The client might want resolution, the client might want closure. And those options are not always available in litigation. And that's why coming to mediation, you will choose a very cost-effective, more expeditious process. You will be in control of letting your attorneys know what you wish to accomplish, not just a position that you take as a solidified side of the fight, but as a compromise that you're not willing to make in any other setting, such as a litigation process. So mediation has many advantages because it offers a cooperative approach, especially to cases in the civil setting, family courts, probate courts, civil disputes, cousins who were partners once and now into a business litigation setting. Some cases would require getting to the end line, either by being in front of a jury or having a verdict come out from a judge, or being in a criminal setting where punishment needs to come in the sense of having a jury verdict. But a civil scenario is most suitable setting for mediation. So give it a try. Ask your attorneys to consider mediation and call in my office, call in CAMS, call in professionals at California Arbitration and Mediation Services to see if we can help. Initial consultation is always available. There should be no charge for any initial consultation. However, in that scenario, in that consultation, do not ask very specific questions, because the consultation is not about resolving your case. The consultation is about offering you more reasons to choose mediation over a conflict resolution process that is called litigation. People often ask, what is the mediation process? Well, mediation offers significant advantages that many attorneys might not initially consider during a litigation process. It's a process where parties, guided by neutral mediator, who is a person who has no stakes in the outcome other than making sure that it does get resolved, creates a cooperative approach. And that cooperative approach does not mean that the parties lose control. If anything, they actually exercise more control and more decision making power within the setting of that cooperative approach. And then that could lead in a much more expedited, much less expensive, and much more mutually satisfying outcome. And particularly in emotionally charged cases such as family law, civil matters, probate issues, disputes over the wills of a loved one who's passed on. Those are the areas where mediation offers the best options, where the parties would leave with the level of dignity that they would like to have, even after the dispute has arisen, and hoping that their resolution would be in a dignified way. What are the professional benefits of mediation? People often ask. One of the key benefits of mediation is that it empowers clients to control the outcome of their case. Instead of leaving the decision in the hands of a judge, or professionals who may or may not have time for all the details that a client is interested in offering as options throughout the litigation. The parties can draft solutions that could suit their scenarios and could allow more effective advocacy. So the parties could be helping their attorneys, whereas otherwise they may not be able to ask attorneys to redirect the gearing of this litigation process, whereas the parties will have an input into their professional advocates. One of the key benefits of mediation is that it empowers the clients to control the outcome of their cases. Instead of leaving the outcome or the decision-making process in the hands of the judge or the attorneys on the sides of the case, the parties involved in the matter can draft their own solutions. They can come up with what suits their unique needs and effectively allow their advocates to really craft a solution that is suitable for their scenario and not necessarily what a third party stranger would be making that decisions for them. One of the key benefits of mediation is that it empowers the parties to control the outcome of their cases instead of leaving the decision making in the hands of others, such as a judge, such as the advocates who are arguing their cases for them. Often the parties need to communicate with their advocates as to what they believe their needs are and not necessarily what the legal options offers them. So that's a unique process where the attorneys are empowered through the communication with their clients, and they could be advocating the cause of their clients with much less frustration, much less indecisiveness, much less control over the outcome, and more importantly, to many people, much less expense. For us lawyers, mediation can also be a more efficient and effective way of resolving our cases. Often the emotions of the parties interfering with our advocacy and being a zealous advocate for our clients makes us forget what the true needs of the clients are. Because we are in a litigated setting, we have to do the most zealous advocacy for our clients, whereas in reality, that may not be what our clients want. And the rush of the litigation process may not allow us to have that heart-to-heart discussion where in a mediation setting with the presence of a neutral, the parties will get to express and stress on their needs as opposed to what their legal options are. And it creates a lot of possibilities where the parties could be thinking of solutions that may not otherwise be available in litigation. Without the stress of a drawn out court battle, without the stresses that reduces our creativity, parties are in best position to particularly get the best outcome, preserve the relationships, do what's important for them, and draft a solution that suits everyone and creates a win-win situation. For us as lawyers, mediation can also be a more efficient way to resolve our cases for our clients. Again, as advocates, we have to present zealous advocacy. We have to offer solutions that are acceptable to the court. We have to offer solutions that protects the best interest of our side of the case. Whereas in mediation, a mediator, a neutral, will offer solutions that are often beneficial to both sides, a win-win situation. That helps create a stressful situation to become less stressful. Anytime we're in a rushed litigated scenario, our creativity is reduced because we are so stressed with the outcome. We are stressed with the fact that we can only speak so much, we can only express ourselves so much. Whereas in mediation, the timing, the expressions, all are within our control. Mediation is also appealing to us as lawyers. It can be a more efficient way of resolving disputes. It could open our mind into a stress-free setting where options are being explored without the stress of being the most zealous advocate for our clients. Sometimes being the most zealous advocate for our clients could create a lot of stress and does not allow the clients to express themselves with other options that they might be interested in. So when you come to mediation, or when we choose to use a mediator in the process that is already in court, that's already in a very stressful setting of a litigation, we might forget about the compassionate ways of looking at problems, and not only the cost-effective ways of resolving a litigated matter, but also providing a more customized, a unique way of creating a long-standing solution that preserves the dignity of the parties. My name is Soheila Azizi, and I'm one of the panelists on CAMS Mediation. CAMS stands for California Arbitration and Mediation Services. And although I'm a panelist as a mediator, or a settlement officer, or an arbitrator, I'm also a lawyer. I'm a litigator. I'm someone who goes to court to litigate a matter to the end, whether it's a jury trial, or whether it's a verdict from a court, or whether it's just a resolution by settlement. As an attorney, mediation appeals to me as well. As an attorney, mediation appeals to me, although I am a CAMS panelist and I would like to promote mediation and arbitration. My name is Soheila Azizi. I'm a panelist on CAMS, standing for California Arbitration and Mediation Services. Although I'm a mediator as well as an arbitrator, a settlement officer, if you will, I'm also a litigator. In my practice, I litigate cases to a verdict, whether it's from a jury or from the bench, from a judge. As a litigator, mediation also appeals to me because it offers many more solutions that litigation does. As a mediator walks into a mediation setting, options open up. Ideas beyond zealous advocacy present themselves. The parties will see the stress-free setting where they can express themselves and seek solutions for what they think their needs are, as opposed to what the law believes their options should be. Um, at CAMS Mediation, all of us are very mindful of the litigation process, of the fact that many cases need to end in a verdict by a jury trial or by a judge. However, we would like to offer the conflict resolution alternatives that are available at CAMS. So, as a litigator, I would like to encourage my fellow attorneys to consider recommending mediation to their clients. I particularly encourage them to do that because it offers a quicker, less adversarial resolution, and it would be beneficial to reduce the amount of stress, creates more creative and collaborative setting where solutions are easily presenting themselves without the zealous advocacy that we as attorneys would like to promote for our clients. So if you like to give mediation a chance, reach out to CAMS, check us out. And if you want to have me as your mediator, please be informed that because my litigation practice covers a large area of practice, such as civil litigation in personal injury matters, in family related matters, divorces, probate, estate administration, disputes over wills and trusts. I've mediated more than thousands of cases in court, as well as in my private mediation practice, and have a diverse litigation practice that allows me to see the role of the attorneys as litigators, allows me to see the role of the mediator in a process, and allows me to see the role of the parties in a mediated process. So reach out to CAMS, check us out, and let us handle your matters for you. My name is Soheila Azizi. I'm a litigator at the law offices of Soheila Azizi and Associate, which is a professional corporation. We're located in Rancho Cucamonga in the Inland Empire. We offer a variety of services. Although I'm a litigator and I can fight cases in court all the way to a trial, I'm also a mediator. When I wear a mediator's hat, I offer many more solutions and options that I believe are less expensive and less stressful and allows the parties to be in control of their situation and the outcome that they desire to accomplish. At the law offices of Soheila Azizi, we offer many ways of resolving a dispute. We would like to inform and educate our clients as they walk in through the door as to many options that are available to end a conflict, to resolve a dispute. Many people consider mediation as an alternative dispute resolution. I believe that the world has come to realize that it is one of the ultimate ways of resolving a dispute. It preserves the dignities of the people. It preserves the civility of the process. It preserves the control and decision making of the parties. And it does all of that at a setting which is more peaceful, more dignified, and less of a cost and expense to the parties. Many people ask the question of the difference between mediation and litigation. Litigation starts with filing an action in a court of law. It could be a civil court where a complaint is filed, for example, by two parties in a partnership, or it could be filed in a family court, which would be called a petition by a petitioner and a response that is required by a respondent. Or it could take many different forms. However, being in court, having a file in the court starts a litigation process. How you end that process is what makes a difference between a litigation process versus a mediated process. So reaching the end line of a litigation involves many steps in the process, such as discovery, exchange of information, investigation, depositions, interrogatories, finding facts before you get ready for a trial. In a mediated process, you could still engage in exchange of information, However, so much of it is protected. The parties will stretch beyond their limits to make sure that they can get their cases resolved without having to physically be present in court. And that's how you reach out to a mediation outlet such as CAMS, standing for California Arbitration and Mediation Services, or you can reach out to my office, Law Offices of Soheila Azizi and Associate, and ask for how we can offer mediation process as well as a litigation process for ending your disputes. People often ask what the difference between mediation and a litigated process in court is. In litigation, the case starts with filing an action and ends with a verdict or a judgment or a stipulated agreement that closes the case. Those are the options that are available in court. In a mediation, you can reach the same outcome without the expense and the delays that a court process entails. Our office offers many ways of resolving a dispute. When a client walks in through the door or reaches us through virtual means and virtual spaces, I would like to offer them all of their options. Litigation could be more costly, therefore more beneficial to an attorney. However, our offices are looking out for the best interests of the parties, and we always offer mediation as a potential way of resolving their disputes. They should be given those options and they should be informed about what each process entails. I'll go into details as to what a litigated process entails. Once an action is filed, the next step for that case, whether it's a simple case or a complex case with much detail, the process of discovery is what the law allows for the parties to get engaged in. The process of discovery is expensive. It entails exchange of information through requests by each party to be providing the answers to the process so that the information and fact gathering could be completed. It could entail written discovery, it could entail oral depositions, it could entail many ways of exchange of information that will provide the parties with what would be called as evidence at the time of trial. I'd like to talk about the advantages of using my office as your legal source. We like to take pride in the fact that we do offer many options throughout the process. Once a party enters into a litigation process and asks me as my client what other options are available, I would like to offer the options at every stage of litigation, which could entail discussing the case with the opposing side in an amicable way or pursuing a very zealous advocacy. I often explain to the clients that in our office, you are able to control the temperature of the process from simmer to broil. It has to do with the choice of the client. Zealous advocacy is often expensive, stressful, and takes a long time to get to the end line. In our office, we'd like to tell all the facts to our clients, explain the process to them, and at every step of the process, to ask them if they have the heart, if they have the means, if they have the resources of continuing with zealous advocacy, or would they prefer to have a less stressful, such as a mediation? Okay. Okay. Mhm. Yeah. I'd like to use the example of serious personal injury or wrongful death cases, or when there has been neglect in a nursing home setting or in a hospital, or some mistake by a professional healthcare provider. Those are the questions that I answer a lot throughout the day. Those are complex cases, and each one deserves its own assessment. However, the beauty of having a counselor by your side whom you can trust, whom you can check your options at any given time, whom you can check your emotions at every stage of the process with that consultant, is very important in your selection of the attorney who will litigate your case for you. In my law firm, we like to get to know the client. We become a part of their family. We become part of their case. We own the process as we step into it. This is not just a file or a number in our office. I give my heart and soul to the case, and my clients vouch for that. My clients sometimes believe that we have become a family. We have become parties to a relationship that will last for a lifetime. And that's the kind of service you can expect from our office. I take pride in getting to know my clients, getting to become personally involved in their matters, and to own their cause to the extent of becoming the cause for them. I hope that appeals to some listeners or viewers, because I have been told that that kind of service, that kind of intimacy in relationships between lawyers and clients is disappearing from our field of litigation and advocacy. And I would like to emphasize how important that is for me to be the trusted confidant of my clients. People often call our offices to ask about the process of starting a personal injury case or a wrongful death case or a case against a professional healthcare provider or a facility such as a nursing home or a hospital. I have to be very sincere in my conversations with the potential client. I will have to explain to them that it often takes years before reaching a resolution. I have to explain to them that it takes a lot of strength emotionally and financially, and a partnership that is very strong and built on trust between my office and my clients before we can see this to the end line. Various stages of discovery, all the way to the end of the case, involve many types of interactions between the client and the attorney, between the client and the opposing sides, between the client and the experts of the case, who may at times have to examine the parties, who at times may have to render opinions that will have to be used in trial of the case, or at times the defense will do every effort to get rid of the case prior to the end line, which is the stage of a trial. Our offices have been equipped with strength of having a large pool of experts, with having expert institutes that are supporting our causes, who believe in the causes that we take on, and who will do everything to provide us with the best equipment to get us ready for the fight in form of a trial or in form of a summary judgment. A few questions that come up often in the field of professional healthcare providers malpractice is whether people really understand what a professional healthcare provider malpractice is. And that raises the questions of how many things does one have to prove in a setting where your opponent is a professional healthcare provider. It sounds complex, it sounds sophisticated, and yet you need a professional that knows their ways of maneuvering around this very complex state of litigation. I will use the example of a professional healthcare provider in form of a dental malpractice case or a medical malpractice case, because that is often a very complex area where questions revolve around how does it start, what constitutes negligence, what constitutes neglect, for example, if it's in a nursing home setting, or in some areas of the law where different definitions are necessary to establish a case. More often than not, good cases are ignored by the parties, either by sitting on those cases for too long or by not understanding the components of what constitutes a professional healthcare provider's case. The statute of limitations are the most sensitive and serious areas of the law that leaves many of good potential cases that would have had high chances of recovery be dismissed based on the statute of limitation having been expired. Many government facilities have statutes of limitation that are much shorter than what common belief and understanding of lay people are. It's very important for you to be communicating your area of concern if it has to do with professional negligence, be it medical malpractice, dental malpractice, hospital negligence, nursing home neglect and abuse, financial elder abuse. Those are areas where you cannot find the answers very quickly by researching or Googling the answers. You need to contact a professional law firm that handles those matters. One of the most important questions that comes up in the areas of professional negligence and professional healthcare negligence is the use of experts. Experts can be very expensive. Experts can often vary from the treating physicians. Experts have to be researched and investigated so that you could go to trial with the help of that expert with absolute confidence that they will maintain their neutrality, that they will maintain their focus on the case, and they will be equipped with being cross-examined or questions or tested with the questions that comes from the opposing side. One of the questions that is most often asked when discussing professional healthcare providers' negligence, such as medical malpractice, dental malpractice, nursing home neglect, or hospital negligence, any of those areas where there is serious personal injury involved, and people ask about how the fees are to be determined. Those fees are considered contingency in California, meaning that the attorney cannot recover their share of the fees until they actually provide recovery for their clients. Another aspect of a litigated case as it relates to dental, medical, hospital, nursing home, abuse, negligence, neglect has to do with retention of experts. That is one of the most expensive aspects of litigation that the parties may or may not know about. Not knowing that the case takes longer than you understand it to take, not knowing that the case involves expenses that you may not have been prepared for, could cause frustration and stress and sometimes conflict between the attorney and the client. In our law firm, we try to eliminate and to reduce the amount of stress and conflict for our clients. That's why we offer full explanations of the process at the very early stages of consultation. We have been in practice for 3 decades now. People refer to our law firm as firm for life. And for that reason, I get many inquiries from past clients, from referrals, and people who come to us just because they trust the law firm, they trust the representation. However, it's important to know the areas of practice that are offered with every law firm. We are a general civil litigation law firm. We do offer criminal defense as well. We offer probate and estate administration matters services that will take us to courts that are not your typical everyday court of a civil litigation, but they are considered probate courts. They are considered family law courts. They are considered, juvenile dependency courts. Those are areas that is important for you to know about. Many people call our offices asking whether we practice a specific area of law. And our answer is often, what are the facts of your case? It is mind boggling how people can be mistaken as to what different causes of action could one set of facts entail. People explain something when they think it's a professional healthcare negligence, whereas in reality, it could be premises liability. They often talk about things that they think has a 2-year statute of limitation, and therefore they have waited all that long before calling a law firm. Turns out that the statute of limitation would have been a much shorter one. The area of practice really determines the statute of limitation, the time that expires before you can start taking action. That is so important for you to be able to distinguish the areas of practice. There are many courts that are available for individuals or for the government to be pursuing a cause of action. Criminal courts are to pursue crimes, and those crimes are often occurring against the state or the county, it's so abhorrent and offensive that the government and the agents of the government are responsible to take action on. Some of those factual scenarios lend themselves to a civil litigation. For example, robbery, rape, situation where a crime has occurred and the criminal defense system and a prosecution by the state or the county government is pursued in a criminal court, could also have consequences that are pursued in a civil court. And that could be where damages, monetary compensation is being pursued. Although the crime is being litigated in a criminal court, the components of a civil action could allow the individual to be retaining representation in a civil matter. The cases could go shoulder to shoulder, or the cases could be upon expiry of the term of the other case. However, the statute of limitation for the civil matters needs to be taken seriously, and waiting for one process to end is not a good justification for waiting. Okay. My office offers services within the areas of law that are related to the families: family law and divorces, custody and visitations, support matters, and pursuit of domestic violence actions. Restraining orders are often brought into our office as areas relating to the families. It could be between a parent and a child. It could be between the couples. It could be between married individuals. Our office offers many services as it relates to those areas that I mentioned. However, many additional areas sneak into the family law settings that are not known to the parties. For example, if a couple owns a business together, that could take us into a field of bankruptcy. That could take us into a business litigation if there are other partners involved that will not be handled in a family law court. It's very important to know the pieces of the puzzle. It's important to know a trusted confidant that could give you the full picture of what your case entails and allow you to move and maneuver from one court into another and assess the possibilities that the case has in being pursued in various courts. Another area that relates to litigations where parties to the case are family members are the areas dealing with wills and trusts, administration of those documents, and also handling matters dealing with conservatorship and guardianship, or having to do with probate court that brings the family members into the court settings. One of the areas of the law that relates to wills and trusts, having a deceased family member, having the interest of an elderly pursued in form of a conservatorship or guardianship, those are matters that are being handled by our law firm as well. One of the important areas of the law that is being handled by our office is the area of probate actions, the area of the law that has to do with writing wills, writing trusts, administering those documents, pursuing any kind of dispute or conflict based on those documents, as well as trying to get protection for our elderly, as well as establishing conservatorships, establishing guardianships. Those are the matters that are often brought into our attention in our office and could be the cause of unnecessary complications and disputes where the parties do not know where the law stands and do not know simple answers to some sophisticated questions that arise. Our office offers legal representation in many areas relating to the probate courts, and it has to do from the time of need for elders to be protected by their family and children, the time to write wills and trusts, the necessity of writing a will, the necessity of writing a trust. Many people are often confused as to whether the level of wealth that they have is even necessitating the writing of a will or a trust. And those questions or those confusing areas could be addressed in a simple consultation with our office. Make the right decision and call for a consult before it's too late. Many people come to our offices when things have already occurred and Incidents that could have been prevented have already taken place, and the law does not offer many solutions for those problems. You do not act timely. So regardless of what area of the law is of your concern, consult with an attorney early on. Time could be your enemy. Time could work against many possible recoveries that are available to individuals and parties and organizations if they act in a timely manner. Do act in a timely fashion by consulting a professional about your legal matters. Another area related to relationships that our office offers representation on is the domestic violence, the procurement of restraining orders, and it could be among family members, it could be among children and parents, and it could be among friends with intimate relationships. Our office would like to make a call to action. Time is of the essence. Facts and documentation of the incidents are of the essence. Consulting a law firm immediately upon an occurrence is of the essence. Timing of reporting, whether it's to the law enforcement or to the appropriate authorities or to a legal consultant, carries a lot of advantages, and not doing so will work against the individual who is otherwise entitled to the protections of the law. Many individuals who are the victims of domestic violence do not act in a timely fashion. Time is the enemy of a victim. When years and years pass by and no documentation of the violence, no documentation of the incidents that have repeatedly occurred, will be assisting the individual to prove their case in court. Evidence is an important component of a domestic violence case. One of the important considerations in the area of family law is protecting the individuals and the children and those who are exposed to the risk of harm and safety. Please act swiftly if you feel that your protection or the protection of those within your care and custody is at risk. You are to reach out to individuals who can provide those protections, whether it's the law enforcement. Cannot hesitate in seeking help, and definitely legal consultations.